According to the Data Institute at the University of San Francisco, historically, epidemics are a time of fear, confusion, and helplessness because men are faced with danger and uncertainty. And at least according to human psychology, man has only two choices in the face of crisis: fight or flight. Some men run and some men stay, some men fight and some men flee. But fortune, at least in the Ranger Regiment, always favors the bold. Hello, my name is Major Mike Webb, retired Army Ranger and formerly the Operations Officer for all U.S. Army strategic counterintelligence in the continental United States. And when an invisible enemy that emerged in China had traveled to the United States, when most everyone began to run away, closing businesses, churches, and schools, placing social distance between themselves and others, and doing anything that they could to avoid confronting a novel coronavirus, I decided to do things just a little bit different. I decided to do it the Ranger way and became a person determined to catch COVID-19 in court. And the following are true crime stories that arose in my determination to catch COVID-19. As you may suspect, when it comes to criminal law, the admissibility of flight evidence does not depend on whether the flight was triggered by an actual indictment or pending indictment. And it is the act of departure that is itself of evidential value. Moreover, evidence of a defendant's flight after a crime has been committed is admissible to prove his consciousness of guilt. And under 18 U.S.C. section 1512, a racketeering offense. It is actually a felony offense, punishable by fine and or up to 20 years in prison for whoever corruptly persuades another person or attempts to do so or engages in misleading conduct toward another person with the intent to evade a summons or to be absent from an official proceeding to which such person has been summoned by legal process. And while most of you probably saw the movie, the mobster Al Capone, the Untouchable, was caught for tax evasion. But in the true crime story, the case for tax evasion was actually built while Scarface was already in prison. According to the FBI files, the Chicago crime boss was actually first brought to justice because he had attempted to evade services of summons, went all the way down to Florida on a fishing trip when he had been called in for questioning about the Valentine's Day massacre in Chicago. And that's a great way to begin this story about the usual suspects that began to evade the jurisdiction of the courts, fugitives from justice from an early point in the public health crisis, which at least raises the reasonable question as to why any rational, innocent person would run from the law if they were only trying to prevent the spread of a zoonotically evolved disease, like a novel coronavirus. On April 4th, 2020, the first and longest surviving case against the lockdowns was filed in the Alexandria Circuit Court, naming as defendants former Virginia Governor Ralph Northam, several other state agency heads to include Dr. Muhammad Norman Oliver, the former state health commissioner, and Mayor Justin Wilson, the mayor for the city of Alexandria. And while the mayor took a little time to finally come to court, the governor decided to do, guess what? Do an Al Capone and evade a summons, which is a predicate offense under the federal racketeering statute, amongst other things. But to establish a pattern, a racketeering activity, you require at least two predicate offenses within a period of 10 years. And so in June 2020, when the facial coverings mandates were issued, we decided to summon the former governor to come to court again, but this time at the federal district court in Richmond. And for some unknown reason, Governor Northam decided to elect a dubious right to remain silent and attempt to evade a summons again. Later on in the litigation, he even decided that he, like Al Capone, was sick and claimed that he had caught COVID-19. But the third time was the charm, when, immediately after the Independence Day celebration in July 2021, an action was filed again against, now, the vaccines mandate. And Ralph Northam decided to run yet again. Those actions went all the way to the United States Supreme Court, and for unknown reasons, Governor Northam elected a dubious right to remain silent and never made an argument or sent an attorney to appear on his behalf, which raises a reasonable inference of suspicion, because the admissibility of flight evidence does not depend on whether the flight was triggered by an actual indictment, as it is the act of the departure that is itself of evidential value. And evidence of a defendant's flight after a crime has been committed is admissible to prove his consciousness of guilt. But at least in the criminal law, the burden of proof required to convict the defendant is evidence beyond a reasonable doubt. And so last summer, we decided first to bring an action against the former governor for violation of the FACE Act, which under 18 U.S.C. section 24882 makes it unlawful to block the entrance to the places of worship. And in December 2020, after the decision was handed down by the United States Supreme Court, former Governor Northam had conceded that he had, in fact, abused his authority when imposing restrictions on places of worship. And would you believe that Governor Ralph Northam decided to try to run yet again? Well, you can run, but you can't hide. And in September, after filing an action in the circuit court for the county of Chesterfield regarding the events surrounding the infection and later death of Bishop Gerald Glenn of the New Deliverance Evangelistic Church in Chesterfield, and who had preached against the social distancing mandates, Darren declared that he was essential and that his God was bigger than a dreaded coronavirus, but who had died before Easter, along with 30 other Pentecostal faith leaders. Within just 2 weeks, the court had certified the matter to the Chief Justice for the State Supreme Court, and it will be very interesting to see whether or not Ralph Blackface Northam decides to try to run again or claim he's caught COVID-19 with or without his mask. Under American law, the term moral turpitude refers to behavior that shocks the public conscience as being inherently base, vile, or depraved, while conduct deliberately intended to injure in some way unjustifiable by any government interest is the sort of official action most likely to give rise to the conscience-shocking level, rebutting even a claim in defense of sovereign immunity, which is alive and well in Virginia. Under the laws of Commonwealth, as expressed by the state Supreme Court in 1884, in the matter Hill v. Woodward, that court stated, by her conduct, as disclosed by the record, the appellant is estopped from questioning the verity of the record. Her evident knowledge of the pendency of this suit and its object, her seeming acquiescence, and her delay in refusal to speak, though not served with notice in the regular way, makes it proper for her to remain silent now that others have acquired rights, while she was standing by in silence, if not in actual acquiescence. It was not only competent for her to speak in time and be made a party if she had not been, but it was her duty. This briefing is unclassified. Stay tuned for the next episode on Catching COVID-19 True Crime Stories. My name is Major Mike Webb, and by God, I am running for state delegate in Virginia's 49th district. No man is above the law. Honest. This advertisement was authorized by Mike Webb.